Hello friends, welcome to my channel. Today I'm going to deal with cases relating to professional misconduct and contempt of court. Ekhon Guwahati University Professional Ethics and Professional Accounting System syllabus. This is the syllabus. So we're going to discuss about some of the important cases. Important cases like discuss. The first case is Pawan Kumar Sharma versus Gurdayal Singh. Citation to Manarakhibalige AIR 1999 1999 SC 98. Citation to Man tough now. Remember. It all facts of the case. Sharma enrolled as an advocate in the Punjab and Haryana Bar Council. In January 1990. January 1919, Sharma, his own Pawan Kumar Sharma, enrolled himself as an advocate. So, at the time of his enrollment, his family was doing taxi business and he himself having 4 taxis in his name. Sharma Sarikhon taxir owner asil during the time of his enrollment. Jetia teo bar council enroll korisil hikini samayত teo Sarikhon taxir owner asil aru tor family to taxi business kori asil. So a complaint was filed against him alleging professional misconduct. There against a complaint filed kora hoisil that they professional misconduct korise, that taxi business run kori asil because as an advocate advocacy bahire beleg eko business for profession ba salaried officer ba employee hisabe kotu indulge hobo nware. Heto hol general rule. So it hol Bar Council of India rule. Since the State Bar Council could not able to dispose of the complaint within 1 year, State Bar Council complaint to dispose of noarile within the period of 1 year, 1 বছৰৰ ভিতৰত হেকনে to transfer কৰা হৈছিল Bar Council of India BCI transfer কৰা হৈছিল. Then Sharma necessary documents provide কৰিছিল. Proof কৰিবলৈ যে তেওঁ taxi কিখন বেছি দিছিল after the enrollment, যেতিয়া enroll হৈছিল তেওঁৰ nameটো Bar Councilত, তাৰপিছত তেওঁ taxi দুখন চাৰিখন 4 taxi বেছি দিছিল. But the Bar Council of India did not accept this document. But Bar Council of India he documents can accept কৰা নাছিল আৰু finally এটা order pass কৰিছিল তেওঁক suspend কৰিছিল from the practice for a period of 1 year. 1 বছৰৰ কাৰণে suspend কৰিছিল on the ground of professional misconduct. Then Sharma order to challenge কৰিছে আৰু Supreme Courtক appeal কৰিছিল. Then Supreme Court contending that though he had 4 taxis, যদিও তেওঁ 4খন taxi আছিল in his name, তেওঁৰ নামত মানে তেওঁ owner আছিল 4খন taxi before his enrollment or আগত he had sold the taxis after the enrollment and discontinued the taxi business. তেওঁ after enrollment হোৱাৰ পিছত taxi 4খন বেছি দিছিল and নিজৰ taxi business to discontinue কৰিছিল. The Supreme Court accepted the argument and passed the following order. Supreme Court Sharma's argument accept korise aru tolot dia order khini pass korise. Number 1, simply because a person is the owner of taxis, he cannot be treated as directly doing the business because konoba ejon manhu taxi as a person jodi kiba ekhon taxi owner hoy eto treat koribo nore je directly he business to kori ase. Rule 47 of the Bar Council permit korise as an advocate ok sleeping partner hisabe kiba business thakibole. Sleeping partner mane active partner na hoy, actively business and participate কৰিব নোৱাৰে বা তেওঁ কিবা যদি ফ্যামিলি প্ৰপাৰ্টি ইনহেৰিট কৰে, ফ্যামিলি বিজনেস নট প্ৰপাৰ্টি বাট ফ্যামিলি বিজনেস যদি ইনহেৰিট কৰে হে বিজনেসটো কন্টিনিউ কৰিব পাৰে বাট তেওঁৰ বিজনেসটো ম্যানেজমেন্টত ইনডালজ হ'ব নোৱাৰে, মেনেজ কৰিব নোৱাৰে, actively participate কৰিব নোৱাৰে. So similarly sleeping partner হিচাপে কিবা বিজনেস কৰিব পাৰে যোনটো বিজনেস আৰু এটা কন্ডিশনস আছে which is not inconsistent with any professions, যোনটো তেওঁৰ প্ৰফেশনৰ লগত inconsistent নহয় তেনেকুৱা বিজনেস তে কৰিব পাৰে. Although despite this Sharma documents produced korise that a business to discontinue korise. Then the charge of professional misconduct is a khushi criminal charge. It is almost close to criminal charge. Khushi criminal kintu criminal nahoy, khushi criminal. So it should be proved beyond reasonable doubt or hekane edo beyond reasonable doubt proof koribo lagibo. In this case the person filed the complaint has failed to prove the charges beyond reasonable doubt. In this case charges be like beyond reasonable doubt proof korat fail hoise. So the appellant had produced documents. Appellant means Sharma documents produced korise showing the sale of the taxi after enrollment. Taxi ki khon je sale korise after the date of enrollment. The respondent has failed to prove that it was untrue. Or Sharma je documents kini produce korise showing that the taxi ki khon besi disil after enrollment. The respondent fail proof কৰিব পৰা নাছিল যে হে documents খিনি untrue আছিল. So that's why it was established that the order of the Bar Council of India is set aside. Bar Council of order to set aside kora hoisil and because professional misconduct is not approved. Aru Sharma professional misconductor kane liable nasil boli Supreme Court help korisil. So case to hold Pawan Kumar Sharma versus Gurdal Singh AIR 1999 SC 98. Then second case hold Supreme Court Bar Association versus Union of India. It case relates to contempt of court. AIR 1998 SC 1995 citation yato tough nahoy. VC Mishra, then the chairman of the Bar Council of India, VC Mishra, the chairman is Bar Council of India, BCI chairman VC Mishra, was punished by the Supreme Court for contempt of court. But Supreme Court had punished contempt of court or karne was suspend practice for a period of 3 years. The charges against him was that in the court against the charges the court of insulting, disrespectful or threatening language use কৰিছিল, insult কৰিছিল, কাৰোবাক disrespect কৰিছিল, কাৰোবাক ভয় কৰিছিল, threatening language use কৰিছিল. He has threatened the judges to judgeক threatened কৰিছে. His act has hurt the judges and he has acted in such a way as to abstract the course of justice out of justice or course to lagot obstruct কৰিছে, that বাধা আনিছে the course of justice. So the Supreme Court Bar Association challenged his order. Then Supreme Court Bar Association he order to challenge korise aru tat tolat thoka issue khini raise korise. These are number 1, the Supreme Court while dealing with the contempt proceedings cannot suspend advocate from practice. Supreme Court as it a contempt proceeding to deal kori thake proceedings, dealing with contempt proceeding cannot suspend advocate from practice. Like proceedings to continue thoka period advocate of practice or suspend koribo nware. Second thing, the Bar Council alone can pass the order suspending an advocate from practice. Or Bar Council alone only order pass koribo pare advocate ejonok practice or suspend kora. Why? Because Bar Council, head Bar Council of State Bar Council বা Bar Council of India, Bar Council original jurisdiction entertain করে. First of all, complaint Bar Council of jabo. Afterwards, complaint Supreme Court order jabo aru Supreme Court order joato appeal hobo. Appellate jurisdiction Supreme Court exercise kore aru original jurisdiction exercise kore Bar Council vis State Bar Council aru Bar Council of India. State Bar Council or disciplinary committee loy case to transfer hobo pare ba State Bar Council or case to Bar Council of India lo transfer koribo pare. Eto transfer koribo pare ba original jurisdiction exercise kore. Ta pisot jodi kono remedy na pai tete hale Supreme Court at appeal koribo pare. So appellate jurisdiction. That's right, the Supreme Court vested with only appellate jurisdiction to hear the appeal against the order of the Bar Council of India. Article 129 of the Constitution does not confer any original jurisdiction to the Supreme Court in the matters of professional misconduct. Even Article 129 of the Constitution of India Supreme Court original jurisdiction confer kora nai. The main question before the court was whether for contempt of court committed by an advocate the Supreme Court can pass an order suspending his practice for a specific period. Main question to it was contempt proceedings committed by an advocate Supreme Court kiba order pass koriba pare suspending his practice for a specific period. He manager practice to suspend kora a specific period or karne. Then constitution bans of the Supreme Court or constitution bans a petition to allow korisil aru tat tola thoka order khini issue korisil. Supreme Court's power to punish for contempt is quite wide, yet it is limited. Supreme Court power se karba contempt tor karne punish koribole karne aru he power to wide mane broad bahut area cover kore, yet tathapiu limited. 2. The contempt of the court proceedings, the court cannot simultaneously incur into the professional misconduct also by adopting summary procedures. Contempt proceedings of court at the same time professional misconduct to incur koribo nuare summary procedure adopt kori belai summary procedure adopt kori case to dispose kori dibo nuare. Then 3. Professional misconduct should be incurred only by following the prescribed procedure mentioned in Advocates Act. Advocates Act 1960. Advocates Act 1961 or Section 35 to Section 44 Chapter 5A Professional Misconduct or Procedure eta provide korise. He prescribed procedure to follow kori he only yes me professional misconduct deal koribo pare incur koribo pare. Supreme Court can award punishment only for contempt of court and not for professional misconduct. Because contempt of court is like 1971 or under Supreme Court of power se punishment award kora hetu hobo pare imprisonment, simple imprisonment for a period of 6 months or fine up to 2000 rupees. Kintu contempt of kintu professional misconduct karone Supreme Court punish koribo nware because tar power to ahe Advocates Act 1961 or under aru tat Bar Council, State Bar Council or Bar Council of India original jurisdiction entertain koribo pare. So for the contempt of court, simple imprisonment of 6 weeks is given. Contempt of court against simple imprisonment 6 weeks or dia goise. So this punishment is suspended for 4 years. Aru he punishment to suspend kora hoise sorry bosor a punishment to Suspend কৰা পিছত গৈছে 4 বছৰৰ কাৰণে the punishment shall be activated if VC Mr. again indulges in any other act of contempt of court within the said period of 4 years. Punishment to আকৌ activate কৰা হ'ব যদি VC Mr. again indulge হয় তেনেকুৱা contempt of court actত within the said period of 4 years. So now first thing হ'ল এই কেছটো ৰিলেট কৰে contempt of courtsৰ লগত professional misconductৰ লগত নহয়. That's why Supreme Court power আছে punish কৰিবলৈ কাৰণে. Our council issue raise কৰিছিল যে Supreme Court contempt proceeding suspend কৰিব নোৱাৰে advocate practiceৰ পৰা আৰু appellate jurisdiction বা যি jurisdiction exercise নকৰক professional misconductৰ ক্ষেত্ৰত appellate jurisdiction আছে original jurisdiction নাই but the case itself relates to contempt of court তেতিয়াহ'লে contempt of court act 1971 applicable হ'ব not the advocates act 1961 যোনতে professional misconduct deal কৰে that's why Supreme Courtৰ decisionটো আছিল last. Then the second case, PG Gupta versus Ramamurthy, AR 1998, SC 283, 1998 or case same, SC 283, PG Gupta versus Ramamurthy. So one Mr. Ramamurthy died on 5/6/1980. Now 5/6/1980 that হৈছিল his sister Vidyawati filed a suit for declarations of title in her favor for certain properties of Mr. Krishna Ramamurthy. So their sister Vidyawati filed a suit for declaration of title. So that feel কৰিছিল টাইটেলটো ডিক্লেয়াৰ কৰিবৰ কাৰণে তাই ফেভৰত সিস্টাৰৰ ফেভৰত ফৰ সাৰ্টেন প্ৰপাৰ্টিজ কিছুমান প্ৰপাৰ্টিজ কাৰণে অফ মিষ্টাৰ কৃষ্ণা প্ৰপাৰ্টিটো অৰিজিনেলি বিলং কৰিছিল মিষ্টাৰ কৃষ্ণা আৰু ৰামামূৰ্তি এণ্ড আদাৰ্ছ ৰেজিষ্টাৰ্ড দ্য সুট ক্লেইমিং টাইটেল ইন দেয়াৰ ফেভৰ আৰু বেলেগে সেই সুটটো ৰেজিষ্টাৰ কৰিছে বিকজ সেই প্ৰপাৰ্টিটো সিহঁতৰ ইট বিলংছ টু দেম এণ্ড নট দ্য সিষ্টাৰ অফ মিষ্টাৰ কৃষ্ণা ৰামামূৰ্তি চ' that PG Gupta was the advocate of Vidyawati. PG Gupta namar ase manu asan jonton Vidyawati advocate asel aru Vidyawati asel the sister of Mr. Krishna Ramamurthy. So when the suit was pending, PG Gupta purchased part of the disposed property for rupees 18000 and sold it for 34000 immediately. So যেতিয়া suit pending হৈছিল PG Gupta কি কৰিছিল the purchase কৰিছিল property to disputed property to যোনটো property against কিবা এটা suit courtত pending হৈছিল but PG Gupta যোনজন advocate আছিল the property to purchase কৰিছিল purchased a part of the property for rupees 18000 ইমান টকাত purchase কৰিছিল then ইমানখিনি টকাত immediately sell কৰি দিছিল property to but the property is what kind of property already disputed property to case চলি আছিল pending. Then Mr. Ramamurthy filed a complaint against PG Gupta. Mr. Ramamurthy PG Gupta against a complaint filed কৰিছিল okay Krishna Ramamurthy arrest registered the suit PG Gupta against a complaint filed কৰিছিল before the Delhi Bar Council alleging professional misconduct কাৰণে main allegation asil je he has purchased a part of the disputed property from his client the disputed property to the client pora kinisil during the pendency of the suit to the pending asil since the inquiry was not completed within 1 year so the inquiry proceedings to complete one asil within the period of 1 year ek bosor bhitorot the matter is transferred to the Bar Council of India the matter to Bar Council of India transfer kora hoisil after hearing both the parties to the party hearing lor pisot hunar pisot the Bar Council of India passed an order the order passed কৰিছিল Bar Council of India suspending him from the practice for a period of 1 year এক বছৰৰ কাৰণে প্ৰেক্টিছৰ পৰা সাসপেন্ড কৰি the court held that a shadow of undue influence is present when an advocate buys property of his own client court কৈছিল যে এটা undue influence present থাকে undue influence মানে যেতিয়া এজন person এটা advantageous positionত থাকে আৰু তেওঁ এটা বস্তু কিবা এটা বস্তু বাই কৰে এজন personৰ পৰা যোনজন হেজন personত কৈ somewhat less advantageous position মানে তাতকৈ তলৰ পজিশনত থাকে তেতিয়া তাত কিবা এটা undue influence element থাকে as per Indian Contract Act তৰ মতে undue influenced so হেতে কোৰ্টত হেল্ড কৰা হৈছিল যেতিয়া এডভোকেটে প্ৰপাৰ্টিটো বাই কৰে তেওঁৰ ক্লায়েন্টৰ পৰা তাত এটা শ্বেডো অফ undue influence some elements of undue influence থাকে. Against this order, PG Gupta filed an appeal before Supreme Court. Then a order to against PG Gupta Supreme Court appeal filed korisil. In the appeal, his main contention was that his client or her legal hearist had not filed any complaint regarding professional misconduct and was in the inquiry conducted based on the complaint where some other person is wrong. That appealot PG Gupta kosil je his main contention was that his client aru clientor legal hears say কোনো ধৰণৰ complaint file কৰা নাছিল কোৰ্টত okay he has not filed any complaint regarding professional misconduct or regarding a complaint file kora nasil and the inquiry conducted based on the complaint by some other person is wrong aru inquiry to conduct asil complaint to based kori pelai hetu inquiry wrong asil the Supreme Court did not accept this argument Supreme Court argument to accept kora nasil and passed the following orders to the order kini pass korisil Any person shall file a complaint regarding professional misconduct against an advocate. যিকোনো person complaint file কৰিব পাৰে professional misconduct or grounded against an advocate, not necessarily যোনজন person client হয় বা তেওঁৰ হিয়ৰছে অকল file কৰিব পাৰে, any person কৰিব পাৰে. Bar council shall inquire into the allegations of professional misconduct though the complaint is filed by stranger because the bar council is concerned with the conduct of advocate. Bar council তাৰ বেলেগ মানুহেও stranger এজন বা এজন third party যদি কিবা complaint file কৰে তথাপি bar council সেই matter-টো misconduct matter-টোৰ ওপৰত ইনকিউৰ কৰিব পাৰে, ইনকিউৰি প্ৰসেছিং ল'ব পাৰে বিকজ যদি ষ্ট্ৰেঞ্জাৰ হয় বিকজ বাৰ কাউন্সিল অনলি কনচাৰ্ণ হৈছে যে এডভকেটজন নে প্ৰফেশ্যনেল মিছকণ্ডাক্ট কৰিছে নে নাই বা এডভকেটজনৰ কণ্ডাক্ট ঠিকে গৈ আছে নে নাই কণ্ডাক্টৰ লগতহে কনচাৰ্ণ হয় কোনে ফিল কৰে কমপ্লেইন কোনে ফিল নকৰে কমপ্লেইন তাৰ লগত বাৰ কাউন্সিল কনচাৰ্ণ নহয় দেন থাৰ্ড পইণ্ট হৈছে দ্য অৰ্ডাৰ পাছ বাই দ্য বাৰ কাউন্সিল অফ ইণ্ডিয়া ইজ কনফাৰ্মড তাৰপিছত সুপ্ৰিম কোৰ্টে বাৰ কাউন্সিল অফ ইণ্ডিয়া যোনটো অৰ্ডাৰ পাছ কৰিছিল তাক ছাছপেণ্ড কৰিছিল সেইটো অৰ্ডাৰ কনফাৰ্ম কৰা হৈছিল দেন এনাডাৰ কেছ হৰিশ চন্দ্ৰ সিং ভাৰ্চেছ এছ এন ত্ৰিপাঠী 1997 case SC 879. Mr. Dayaram engaged Mr. Harish Ram as a lawyer in a consolidation proceeding pending before the consolidation officer. So Mr. Dayaram namar ejon manu asil jone engaged hoisil Mr. Harish Chandra logot Harish Chandra Singh as a lawyer hisabe engaged Mr. Harish Chandra as a lawyer in a consolidation proceeding pending before the consolidation officer. Since Dayaram could not attend the case regularly, since Dayaram case to attend regularly, Harish Chandra asked him to appoint a Mukhtar. Harish Chandra Mukhtar as an appoint korok. Dayaram appointed one Mr. Syed Hussain. Dayaram appoint Mr. Syed Hussain Namor, a junior advocate of Harish Chandra as the Mukhtar. Harish Chandra junior advocate as a Mukhtar. Power agent money. There's a Syed Hussain in the capacity as Mukhtar sold certain property. So hisane taro capacity as a Mukhtar, that means power agent hisabe kisuman property sell korisil of Dayaramor kisuman property sell korisil to the father of Harish Chandra father. Now it's confusing etia Syed Hussain property sell korisil kar Dayaramor, but whom? Father of Harish Chandra. Dayaram filed a complaint against both Harish Chandra and his junior Syed Hussain before the local bar council. Local bar council complaint filed korisil Dayarame before against both Harish Chandra and junior Syed Hussain. The president of the bar council forwarded the complaint to UP State Bar Council. Bar Council president case to forward korisil UP Bar Council. Since the matter was not disposed of within 1 year, matter to dispose on a whole 1 year ভিতৰত it was transferred to the Bar Council of India. Dita he case to Bar Council of India transfer কৰা হৈছিল. During the inquiry, Dayaram submitted the following. Inquiry সময়ত Dayaram তলত দিয়া খিনি submit কৰিছিল. Number 1, the Mukhtar was obtained fraudulently. The Mukhtar was obtained. Okay, Dayaram কোনে কৰিছিল? During the inquiry, Dayaram submitted the following. Dayaram কৈছিল Mukhtar যেটো হয় power agent এটো fraudulently obtained কৰা হৈছিল. Therefore, the sale deed executed by using the Mukhtar should be treated as void. So, the sale deed to execute kora hoise using the Mukhtar something like this use kori, then it void will treat kora hoba. Then the act of Harish Chandra and Syed Hussain amounts to professional misconduct, so they should be punished for that. Harish Chandra and Syed Hussain are act to hoba professional misconduct, so he had punishable later. Syed Hussain confessed to guilt, stating that being a junior by disobeying his senior, he did these things and asked for pardon. Syed Hussain then kole the junior asil whom Harish Chandra junior asil. আৰু এজ এ জুনিয়ৰ তেওঁ চিনিয়ৰৰ অবি কৰিছিল আৰু তাৰ কাৰণে তেওঁ পাৰ্ডন asked for pardon. Then Harish Chandra contended that his father was living separately. Harish Chandra contend কৰিছিল যে তেওঁৰ father separately আছে living separately and he did not have any contact with him. Our father লগত Harish Chandra একো contact নাই. He also contended that Syed Hussain is not his junior আৰু তেওঁ আকৌ ক'লে যে Syed Hussain তেওঁৰ junior নহয়. Then the Bar Council of India held that Harish Chandra is guilty of professional misconduct. Then Bar Council of India college Harish Chandra is guilty of professional misconduct and he was suspended from the practice of 2 years. 2 বছৰৰ কাৰণে তেওঁ practice পৰা suspend কৰা হৈছিল আৰু his junior Syed Hussain was pardoned. তেওঁক মাফ কৰা হৈছিল. Pardon মানে মাফ কৰা. That against this order, Harish Chandra filed an appeal before the Supreme Court. Appeal filed kora hoisil Supreme Court. The Supreme Court dismissed the appeal. Supreme Court appeal to dismiss kori disil and affirmed the decisions of the Bar Council of India. Bar Council the decision to confirm korisil. That means affirm korisil. It was an important case. Very important. DC Saxena versus Dr. DC Saxena versus Honorable Chief Justice of India. AIR 1996 SC 2481. Very important case. Dr. DC Saxena was a professor of English University. Tao as a professor, that's why the word doctor is used here. Of English University. He filed a writ petition in the Supreme Court. Supreme Court had a petition filed by way of public interest litigation PILL or throat. Seeking to recover from the Prime Minister পৰা কিবা এটা recover কৰিব বিচাৰিছিল Mr. PV Narasimha Rao, Mr. PV Narasimha Rao, the expenditure incurred for his private use of to expenditure incur কৰা হৈছে private use of Indian Air Force aircraft and helicopters. So to the Indian Air Force aircraft আৰু helicopter নিজৰ private user কাৰণে use কৰিছিল, private কামত use কৰিছিল, তাৰ কাৰণে যোনটো expenditure incur হৈছিল সেইটো recover কৰিবলৈ. The repetition was dismissed summarily. Repetition to summary procedure through dismissed kora hoisil without going into the merit by the bench consisting of Honorable Chief Justice. Merit basis on nujua kohe summarily mane briefly with a quick view dismissed kora hoisil without going into the merits by the bench consisting of consisted Honorable Chief Justice Mr. A.M. Ahmadi and others. Chief Justice bench to part asil. There was Mr. Ahmadi and others. Thereafter, DC Saxena filed the second writ petition. After DC Saxena second writ petition filed against the Chief Justice of India. Even Chief Justice of India against the second writ petition filed. In this petition, he contended that the first writ petition was dismissed by the Chief Justice by receiving brief, and he prayed for the following. By receiving brief, and he prayed the following. Number 1, the respondent be declared as unfit to hold the office of Chief Justice of India. So, respondent be declared as unfit to hold the office of Chief Justice of India. Chief Justice of unfit hoy nisor office hold koribole because summary procedure through without going case to merit basis on nuja koi decide korisil dismiss korisil writ petitions to. Then 2.2, his citizenship should be withdrawn and a case be restored against him for forgery and fraud. The citizenship to withdraw kora jaok jate and then eta case restore kora hok against him for forgery or fraud or karne. 3 directions to prosecute the respondent under the Prevention of Corruption Act or under to prosecute korok. Then 4 directions to the CJI to give him his pocket expenses from his pocket. CJI is a pocket or expenses incurred for filling this repetition to provide. So directions to the CJI to give from his pocket. CJI nijor pocket or expenses diok to the person to repetition fill korise repetition or cost to expenses. Then Supreme Court there against a show cause notice issue korisil cost dekhabole show cause notice. Yes, for contempt of court because several advertisements in the repetitions are scandalous. बहुत किनी बस्तु repetition is scandalous and allegations made a reckless. Allegation made a reckless माने एको ground नहीं सिखने allegations. Reckless attack and the चीज़ें आई. Chief Justice बता reckless attack करिसिल, groundless attack करिसिल. So ये Supreme Court view असिल. So cause notice issue korisil. Saxena denied all the allegations. Then Saxena gotekhini allegation deny korisil. He pleaded that he have filed this petition only in public interest. Plead korisil that he petition to only public interest fill korisil and there is no bad intention in filling this petition. There are no bad intention nai petition to fill korot. He even pleaded that if the court once is ready to withdraw the petition or ready to make the necessary changes in the petition, he tell akka college tell jodi court e bisare tell petition to withdraw korba ba necessary jodi change kanibo lagia hole tehale change anibo petition but petition to bad intention fill kora nasil eto tell public interest according to Mr. Saxena tell fill korisil public interest oporot petition to. So the court did not accept this argument. Court he argument accept kora nasil and held that withdrawal or making changes in a petition cannot cure the contempt. Petition to withdraw kora ba petition to kiba change in a contempt proceeding to cure koribo nware. Already committed by scandalous remark kori pelai CJ report made in this petitions. The court passed an order of 3 months simple imprisonment. Only 3 months or simple imprisonment or order passed korisil and a fine of ₹2,000 of the contempt and the writ petition was dismissed or writ petition to dismiss kora hoisil. These are the scandalous ground. Ekhini hol scandalous grounds by reckless ground jekini DC section is seizure against a writ petition kine likhisil. Basically writ petition public interested fill kora hoy. So everything was Supreme Court order reject kora hoisil scandalous by reckless aru gatu contempt a ground kine contempt proceeding initiate korisil against DC section. So thanks for watching. Yeah, deal kora hoise case relating to professional misconduct as well as case relating to Contempt of Courts Act 1971 contempt proceeding. So please do not forget to subscribe.